Hello, everyone. I'm Prateek Sibal. I'm a program specialist at UNESCO, and I lead the work around artificial intelligence and the rule of law here. Welcome to the UNESCO series on AI and the rule of law. This is the second webinar in our series where we are going to talk about the admissibility challenge when it comes to AI-generated evidence in courts. We will be discussing issues related to AI-generated evidence. In fact, can it even be considered evidence, or as Professor Sabine Gless has written in a paper, we're talking about machine testimony. Then we will deal with questions around bias, around discrimination, around reliability, explainability, trustworthiness, and then also discuss what can judges do. And here, Judge Paul Grimm has some pointers also in his paper, and we'll also be sharing all these articles with you later. Just a brief note on UNESCO's Judges Initiative. UNESCO has been engaging with judicial operators in these kind of dialogues since about 10 years now on questions related to freedom of expression, access to information, safety of journalists, and since about 2020 on AI and the rule of law. We are a community of about 25,000 judicial operators from over 150 countries around the world. And we are very glad to be engaging in this dialogue with you today on artificial intelligence. I would now invite our partner in this webinar, one of our partners. We are partnering with the National Judicial College in the United States, the Inter-American Court of Human Rights. We are partnering with Lawyers Hub in Kenya and the National Law University's Center for Communication Governance in Delhi. And we have Ms. Chalak Kakkar, who's the Executive Director of the Center for Communication Governance here with us to share some opening words before we move ahead. Over to you, Chalak.
Thank you, Prateek. The Center for Communication Governance at National Law University is really excited to be partnering with UNESCO and our other partners on a series of webinars on important issues emerging around artificial intelligence, whether it's emerging issues of IP rights, generative AI, today's webinar on use of AI-generated evidence, as well as the use of AR and VR in courtrooms. We are a research center based at the National Law University in Delhi, and our mandate is to ensure that the Indian legal education system engages more meaningfully with information law and technology. And towards that end, we undertake academic research, policy input domestically and internationally, as well as undertake capacity building of key stakeholders in the system, including judges and government officials. And that's where we've been working with UNESCO over the last couple of years, and have also, been involved in their initiative around training of judges under the AI and rule of law initiative, as well as other panels and events on issues around AI. And I think, it's a really, really crucial issue to be talking about, because the idea of, courts in a rule of law context is the delivery of justice. And there's increasing adoption of artificial intelligence within court systems, overburdened court systems, overwhelmed court systems, in a hope that this will help bring about efficiency and enhance the delivery of justice. But in all of this, we have to balance all the competing interests and ensure that the focus remains finally on justice delivery and ensuring, the realization of the rights of marginalized, vulnerable communities. And this doesn't come at the cost of, core principles that are dear to us in democracies around the world. So we're very excited to be partnering with UNESCO on this particular webinar on the use of AI-generated evidence. And as the scope and use and misuse of AI-generated evidence advances, it becomes really important for us to enhance the capacity of judges and judicial officers, as well as other stakeholders in the system, around how to engage with such AI systems and AI-generated evidence. So I want to thank UNESCO for bringing all partners together to organize this webinar, and I'm really excited to hear what our wonderful panel of speakers has to tell us today. I'll hand over to the moderator, Isabella Ferrari, to kick the session off.
Thank you very much. It's a pleasure to be here. My name is Isabella Ferrari. I'm a Brazilian federal judge. And now for our opening keynote, we're receiving Professor Sabine Glass. She's a professor of criminal law and criminal proceedings at the University of Basel. And she's also a visiting scholar at NUS Law and an expert in criminal law and criminal procedure with a research focus on law, AI, and robotics, and the admissibility of AI-generated evidence in criminal court. She's a professor of criminal law and criminal proceedings at the University of Basel. So, Professor Glass, we welcome you, and the floor is yours.
Thank you very much for this nice introduction. Good afternoon, everyone. And I would now ask to share my slides. And meanwhile, I'm happy to thank everyone who organized this panel for organizing it and all of you participating to engage in another Zoom meeting. As my colleague said at the beginning, we are all very much looking forward when we can perhaps meet personally at some point. What is the admissibility challenge of AI-generated evidence? That's our question today, and I would ask you to go to the first slide, please. The example I will use, and I have used before because many people can relate to it, and also our panelist Stephen Mason is an expert on it, is modern driving, using cars equipped with driving assistance systems. Such assistance systems, like drowsiness detection systems are a great achievement for helping improve safety and convenience for drivers, but also for those around them. But their constant monitoring and assessing of the human performance can lead to that admissibility challenge of AI-generated evidence, because their non-stop observation makes them seemingly ideal witnesses. Next slide, please. Imagine you drive in a new car to your office in the morning, well rested, looking forward to your day, but all of a sudden, the car beeps, the driving wheel vibrates, and the coffee cup sign recommends you to take a break. This alert is based on AI. It's based on the car's reading of your lane keeping, your sitting position, your eyelid movement. And so the alert is what we would call AI-generated evidence. Imagine that you simply ignore this warning because you feel well rested and alert. Yet, minutes later, you hit a motor scooter that you did not see coming. It is easy to imagine further that investigators who examine the accident find that you had been alerted to the possibility that you might be driving while drowsy. The prosecution would want to proffer the alerts recorded by the car as evidence that you had been warned that you are tired and that you actually were tired. Consequently, the prosecutor might level 2 accusations against you: driving while unfit to do so and negligently causing bodily harm, as you should have taken a break or gotten off the road. Next slide, please. This is not science fiction. In Europe, a new regulation mandates all cars to be equipped with a driver drowsiness and attention warning system. And that is from 6th of July, 2022 for new types of cars, and from 7th July, 2024 for all new vehicles. Next slide, please. The admissibility challenge lies in the question, and that's the question that was referred to in the introduction as, providing justice, whether judges as gatekeepers for sufficiently reliable evidence in courtrooms should allow drowsiness detection alerts as evidence in a criminal trial or not. The starting point in all jurisdictions I know is the following. As a rule, all relevant evidence is admissible If there are concerns regarding the reliability, it goes against the weight of the evidence, not the admissibility. It is left for the trier of facts, jury or bench, to decide whether evidence is persuasive. As an exception, however, inherently untrustworthy evidence can be excluded. For instance, a witness testimony proffered as evidence that cannot be tested through confrontation, usually cross-examination, would be excluded. Next slide, please. It would now be interesting to put into detail this rule and exception model in all the jurisdictions represented in our webinar. I can only point to two domestic statutory regimes that are on the panel, and that's the US Federal Rules of Evidence and the Swiss Criminal Procedure. And if you very quickly read through them, you see that Rule 402 of the US Federal Rules of Evidence just allow for the general admissibility of all relevant evidence, as does Article 139 of the Swiss Criminal Procedure that mandates a court with searching for the truth. Next slide, please. But both systems have a safety precaution for reliable evidence, with the accused having the right to confront incriminating evidence. And in the US, that is case law and rules. Will not go further into that. Perhaps Judge Grimm will mention some more, but that's the Sixth Amendment, which gives a right to confront evidence to all defendants. And in Europe again, and that's now true for all of continental Europe and the UK too, Article 6, paragraph 3, gives everyone charged with a criminal offense the following minimum rights, including the right to confront. Now, when these statutes have been written, there was more witness testimony on the minds of the lawmaker, but it has been expanded, and in Europe, prominently by the case law of the European Court of Human Rights in Strasbourg. Next slide, please. The question now arises, how could defendants meaningfully confront a drowsiness detection alert? Now, the traditional way would be that parties or the bench appoint an expert witness, and that the expert witness can explain the accessibility, the traceability, and the reproducibility of such evaluative data like drowsiness detection alerts. But the question is, would this enable defendants to meaningfully confront the incriminating data? And would it eventually enable the trier of facts to evaluate the reliability of such evidence? Our doubts result from the fact that experts in such a scenario face many hurdles. First of all, the so-called black box problem, the issue that internal algorithms or decision-making processes of a system are not fully transparent or explainable. And this concerns worsen as the black box problem may be entangled with a trade secret issue, that is confidential information that the car maker will not disclose because of their protection of a competitive advantage in car design. And these problems are combined with more problems, and that result in what has been described as a mission creep problem or function creep by our panelist, Judge Grimm. I understand in an article that will be shared with you, very interesting article on the problem that sometimes functions of AI systems are expanded beyond its original intended purpose or scope, like using drowsiness detection alerts as evidence in a criminal court, while the driving assistants generating such alerts have only been designed to warn the driver of their performance during driving automation. And this is different from intended forensic tools like breathalyzers or DNA sample tests. Car and driving assistance systems are not designed as forensic tools, they lack a proper metric or certification or any other system that would really document their trustworthiness. Next slide, please. The challenge judges face when deciding on the admissibility of AI-generated evidence is to not block relevant evidence from their courtrooms because justice must be provided, but also to not allow possibly biased evidence that cannot be confronted. And this is particularly difficult with AI-generated evidence that is a result of mission or function creeps, and I'm sure Judge Grimm will speak to that. As we have seen with the example of drowsiness alerts, the evidence provided is a subjective observation of a system like a witness observation, not a measuring operation. For instance, drowsiness detection systems are designed, trained, and calibrated by car makers to ensure that human drivers are ready to take over the steering wheel if necessary. It is very likely that the car producers aim to alert the driver more often than necessary so that they are on the safe side. If such a drowsiness alert is then presented in court, the question is how can a defendant meaningfully confront it? And today we know still very little about how drowsiness detection works in a certain car, but it seems possible that they have what is known as the white guy problem. Such a problem arises when data is used to train such system that is not diverse enough. For instance, the training data used to teach drowsiness detection systems will lack diversity when it's predominantly young white males who volunteer to engage in a computer game used to gather the testing data. And then consequently, the drowsiness detection system may not be accurate when assessing other groups or individuals like elderly females with drooping eyelids or drivers with dark skin. And so I would say overall, a mission creep, a function creep's observation is likely to be biased. Next slide, please. Now, the question we will discuss today is, are there new feasible ways to check reliability of AI-generated evidence? I think there are. I can't explain them in detail here, but please allow me to refer to two works we did. The one is called Carwert MTOR, crowdsourcing data to challenge the testimony of in-car technology, beware of your car. And there we address the situation in which a car acts as a witness against its human driver in a court of law. And we suggest that crowdsourcing data could be a viable option for assessing the trustworthiness of such evidence. And we encourage lawyers, judges, and lawmakers to remain open to such a strategy. In the other article that is for now only published in German, Intelligente Agenten als Zeugen im Strafverfahren, but will come up in a book with Cambridge University Press next year, we propose to go new ways and, for instance, really search for an AI-driven tool that is able to vet AI systems. Next slide, please. Now, it's clear that our propositions raise new questions. And again, I cannot explain them in detail, but it's clear that privacy issue will play a huge role in solving the problem that we have at hand. With that, we come to my last slide. To conclude, I take that AI can, in principle, generate valuable evidence for fact-finding in criminal cases, and that it's important if you want to provide justice. But as it stands now, procedural laws lack the tools for the fair use of it. In particular, we lack rules for presentation in a form that allows the vetting of reliability and the validity for fact-finding. In particular, the confrontation of such evidence in a meaningful way. Therefore, I think domestic lawmakers, and we will hear whether they do that in some countries, must come up with a new proper legislation, and the actors in the criminal justice system must be trained to use or to discard AI-generated evidence. And legislators will have to solve the problem of privacy protection. Thank you very much.
Thank you so much, Professor Glass, for organizing perfectly the topic and for sharing with us your thoughts. And now we're starting the panel. And the first question goes to Judge Graham. Judge Graham is a professor at Duke Law and a former Maryland district judge. So, Professor Graham, how does the increasing use of digital, electronic, and AI-generated evidence in court impact traditional rules of evidence and the legal framework surrounding admissibility? Can you please provide us some cases of where admissibility of electronic or AI evidence was questioned?
Yes, thank you very much. It's an honor to be here. I'd like to sort of pick up where Professor Glass's excellent introduction framed the issues for us. When we're talking about artificial intelligence evidence in any of its forms, including ChatGPT or generative AI, we're talking about non-testimonial evidence from humans. We're talking about information that has been the product of computers. Therefore, the rules that govern its admissibility, as Professor Glass said, are relevance, and the evidence rules of every country that I'm aware of have a presumption that relevant evidence will be admissible. And relevant evidence is evidence that has a tendency to prove or disprove something that has to be decided in the case. Now, the decision as to whether evidence is relevant is made by the judge, and the judge, as Professor Glass said, must be a gatekeeper. Here, you have to keep in mind that most evidence rules, whether they're drafted by statute or in the United States by a committee that proposes rules that ultimately are approved by Congress, the rules tend to be technology neutral, because changing rules takes time, and technology doesn't wait for anyone. So technology marches forward and is immediately used. The different legal systems adjust to this differently. In the United States, the presumption is, and the basic assumption in the rules of evidence is, that members of the community, jurors, will decide civil and criminal cases and decide the facts, and the judge just rules on the legal issues. In many other countries in the world, they don't have the jury system as pervasively for all civil and criminal cases. So this role of determining whether the evidence is going to be considered in determining the outcome of the case falls to the trial judge. As Professor Glass correctly said, there is a tension in the evidence rules where relevant evidence is presumptively admissible, but evidence that is not reliable and can be demonstrated to be unreliable to such an extent that allowing it to be considered in the case would produce a risk of an unjust or unfair outcome can be excluded by the judge, whether the judge is the one deciding guilt or innocence or whether it's a jury. And the way in which the judge approaches this, as Professor Glass said, in all countries, is to look at issues of reliability. Sometimes it's referred to as explainability or trustworthiness. And it really are two components that kind of merge under the notion of reliability. One is validity. Does this artificial intelligence software application do what it claims to be able to do? And the second is it reliable? Does it consistently produce accurate results when it is applied to similar factual circumstances? And the only way in which these questions can be answered is if during the pre-trial phase of the case, the parties have access to sufficient information to be able to demonstrate to the judge the method by which the artificial intelligence application was designed, tested, the purpose for which it was intended to accomplish, and whether or not it is being used in the particular case for the purpose for which it was tested, and if it is reliable and valid. As Professor Glass noted, This implicates issues of trade secrets. The developer of the artificial intelligence software does not want it disclosed. Some judges faced with this problems have protected the trade secret nature as confidential and not allowed it to be disclosed. Other judges, in my personal view, did it the right way. They issued a protective order to enable disclosure to the litigants under circumstances that will not threaten the competitive advantage for the developer of the software. The way in which you have to analyze this is the way in which experts analyze any kind of scientific, technical, or specialized information. Number one, is the person who is explaining how it works qualified to do so? Have they based their testimony on sufficient factual information? Are the methods and principles used reliable? Have they been reliably applied to the facts of this case? And this means that issues such as, has the methodology been tested? By whom? Have the test results been made public? Is the data unbiased on which it was tested? Is it being used for the purpose for which it was designed to be used, which gets into the issue of mission creep? It is these types of questions that the trial judge needs to have information developed during the pretrial phase to allow the parties to argue whether or not these reliability criteria have been met, so that the judge can make that fundamental determination of relevance. Evidence that is technical, that is not valid and reliable, does not tend to prove things. If it doesn't work, it doesn't prove things, and therefore it is not relevant. So this is kind of complicated, but it hinges upon the judge's management of the pretrial phase of the case to make sure that the information is necessary for the parties to argue about whether these fundamental evidentiary concepts have been met, and the judge to determine whether or not it is admissible. If it is admissible, then the weight is to be decided by the fact finder. You asked for me examples of when it's been used. I can tell you right now that in civil litigation in the United States involving an automobile, Professor Gless, as you indicated, this was a self-driving automobile. In 2007, Elon Musk went on to, was interviewed online, and it was posted on a website. And he was saying that artificial intelligence applications in the manufactured cars by his company are safer than human drivers and are perfectly safe. In an accident involving a pedestrian, the lawsuit attempted to introduce those comments from Elon Musk into the civil litigation. Musk's attorneys objected and said, there are so many examples of him in the public sphere talking that through deep fake technology, you can take that language, put it into a computer, type the text that you want it to say in the computer, and it will replicate his, in his language, the language you want. And judge, we want you to exclude it. The judge said, no, you are saying something is a possibility, but you have not demonstrated in this case that this is what happened, and therefore they have excluded it. And I think that perhaps Professor Mason may be able to provide an example of this, but I'm aware of one case in the UK. It was a domestic case in which the wife introduced what was purported to be a video recording of the husband saying something that indicated that he was an unfit parent. The court issued an order based upon that, and upon appellate challenge of that order, the father was able to demonstrate it was a deep fake, and therefore the evidence was excluded and the result was changed from the court. The challenge that we all face, and then I'll turn it back over to our moderator, is that there is a dual threat here, because the ability to demonstrate that some evidence that appears to be authentic is actually fake creates the issue that the outcome of the litigation may be unjust, because unauthentic evidence is accepted as authentic. But on the other side, the public awareness and the pervasive knowledge that this technology enables evidence to be faked allows a person who has evidence that is authentic offered against them, which is the result of computer systems, can now argue in a conclusory fashion, this is a deep fake, and you now run the risk of having the fact finder confused and believing that authentic evidence is not authentic. So it's a double threat. And this last example is what has been referred to by Professor Citron in the United States as the liar's advantage. So these are issues that judges are facing, and I'll turn the control back over to our moderator.
Thank you so much, Professor Grimm, for this enlightening answer. And now we receive Professor Stephen Mason. Professor Mason is the founder, publisher, and joint editor of the Digital Evidence and Electronic Signature Law Review. He's a visiting professor at the National University of Singapore, visiting lecturer at the School of Law, University of Tartu, Estonia. He's an associate research fellow at the Institute of Advanced Legal Studies, School of Advanced Study of the University of London. And he's also an expert on electronic signatures and electronic evidence. Welcome, Professor Mason. And
thank you.
Our first question to you is, what are some of the limitations inherent in machine learning that make it difficult to prove the reliability of AI systems?
Thank you very much, Judge Ferrari. It's much appreciated. Judge Grimm, I wasn't aware of that case that you mentioned, so maybe at some stage you can let me know a little bit more about the names involved and I can look it up. But usefully, that illustrates a problem I think that we all face, which I recognized 20 years ago when I started writing on this topic, and that is that although we have the most marvelous access to apparent good quality information via the internet, the big problem now is sifting through what we might call the dross in English, that which is of no value, and also recognizing areas where of information where you can actually rely on the information being given over to you. So I'll try and follow that one up with you. That sounds very interesting, and I apologize for not knowing anything about it. In order to sort of respond to that question, I thought I would mention that way back in 2015, myself, together with a US lawyer called Timothy Reiniger, we wrote a paper called Trust Between Machines, Establishing Identity Between Humans and Software Code, or whether you know it is a dog, and if so, which dog. That's in the, this is in the references that you will be provided after the event. That began my search into how we look at software code and compare it to how we live in the human world. And then in 2017, I wrote a follow-up article on my own entitled Artificial Intelligence, Oh Really? And Why Judges and Lawyers Are Central to the Way We Live Now, but They Don't Know It. I suspect that everybody attending online this event now will probably readily recognize that they probably know that they are now an important cog in this machine. And if at the end of this hour and a half, you didn't know before, you probably know now. And for those who know me, they will know that I've been trying to get the British establishment to educate lawyers, would-be lawyers and judges in this topic for almost 20 years without any success. I'm hoping this will change things. Now, those thoughts, most early thoughts of mine, bearing in mind I'm not an IT chap, I'm a historian first and a lawyer second. I'm just going to look at large language models, which is what we might call loosely artificial intelligence is mainly about, but not only. I've been passing to and through a lot of discussions with technical people who know about AI to try to make sure I'm at least roughly accurate by what I say. For those people who know far more about the technical side of AI than me, please correct me if I'm wrong at some stage. I really do appreciate that. But I'm going to base this response on a paper written by Murray Shannon, Shananan, who is Professor of Cognitive Robotics at Imperial College London in the Department of Computing. And he is also a senior research scientist at DeepMind. His paper is incredibly important, and I've included it in the list of papers to for you to read afterwards. It's an open source, and I provided a link. He wrote a paper called Talking About Large Language Models, and this is what I want to. I'm unashamedly using his language here from his paper, because after my initial thoughts of AI way back in 2017, he has helped me crystallize his thoughts, and he says it far better than and more eloquently than I can do. But when we talk about conversations, so if we have a casual conversation or make a speech, such as me speaking now and you listening to me, or we send an email or a letter or something like that, we are actually engaging in an activity that is built upon a foundation. What we say makes sense because we inhabit a world and we share with other language users. Now, of course, we have simultaneous translation as well during this course of this session. So we're talking about different languages simultaneously as well. But the point is, we all share the language, the exchange of language. What happens though with a large language model is very different. A large language model they generate mathematical models of the statistical distribution of tokens in the corpus of human generated text. And these tokens will include words, parts of words, individual characters of words, and punctuation marks. And of course, it will do it in all languages as well, or whatever language you choose to ask it to. So we must understand what we call large language models do in comparison to humans. So Professor Shananan has given an example, which I use here, which is quite useful. You can ask this question: ask the first person to walk on the moon was, and leave it at that. Now the question is, what is being asked? I'll explain the blackout later on, rather than interfering now. The model is being asked the following question: given the statistical distribution of words in the corpus of the English text, what words are most likely to follow the sequence the first person to walk on the moon was? And as we know, the correct response was Neil Armstrong. Now, how do we as human beings look at that in comparison to the language model? Well, first of all, the real world is the basis for knowing the truth to the question, as far as we are concerned. We know the moon is a physical object. We know that Neil Armstrong is a human being, and we know his walking on the moon is a fact about the physical world. But to the large language model, the computer, the software, has no knowledge of the physical world. It has no knowledge of what it is to be human or what physical objects are. The function of this model is merely to generate statistically likely continuations of word sentences. The language model does not know anything because at a fundamental level, it is just a sequence prediction. And the special relationship of propositional sequences have to truth is apparent only to the humans who have asked the question and to those who have provided the data the model was trained on. And as a side issue, which has probably been discussed tangentially by Judge Grimm and Professor Glass, is that the data itself, of course, is open to bias. And there's both case law and articles on this. So in the context of artificial intelligence, I must admit, I don't like that word. I call it algorithmic intelligence or something similar. First of all, one of the first problems is the one I've just outlined, the difference between humans and the large language model. Secondly, as already been alluded to by Judge Grimm and Professor Glass, is that we need to find appropriately qualified digital evidence professionals to advise the lawyers for every party. And please note, I use the phrase digital evidence professionals. This is actually very important. We should not be using the words IT specialists. IT specialists are not digital evidence professionals. I spent 9 years in the British Army in bomb disposal. And when we used to turn up to a bomb, we were called the experts. And we used to say an X is a has-been and a spurt is a little drip of water. In other words, we were saying to people, we were only good as the last bomb we dealt with. And we're still here with all our fingers. And this is the same when it comes to providing expert evidence to courts. There is so much to know now about computer systems in their wide variety. Nobody can be an expert in everything. So the reason why I discussed the use of this phrase with the head of forensics in the Netherlands about 3 or 4 years ago was that it is important to call yourself a digital evidence professional or forensic professional, because by doing that, you are admitting that you don't know everything. And as we all know, experts should say to a court or their lawyers, there are areas which I know nothing about at all, but this is not happening as frequently as it should do. The third problem we have, if it exists in your particular jurisdiction, is that computers are considered to be reliable. There's a legal presumption in England and Wales that says computers are reliable. Now, for those people who are familiar with my journal, the Digital Evidence and Electronic Signature Law Review, and also my textbook, which I edit with Professor Seng in Singapore, you will know of the English legal scandal, which is the worst in legal history in the UK, in England, about the Post Office Arising case. I suggest you look at our practitioner text, chapter 5, for more information. And we started publishing articles on this from 2000 onwards. And finally, again, which Judge Grimm and Professor Glass mentioned, we have the sheer complexity of the software systems and the problems that brings about that. And it's very important for us to appreciate the complexity of this. So in trying to answer that question, I've looked at what LLMs do against human beings. And last but not least, I published 2 articles, one in 2021, one by Professor Michael Jackson, about an approach to the judicial evaluation of evidence from computers and computer systems, and also another paper, recommendations for the probity of computer evidence. Again, I've passed these details on to Charlene and Pratik, and they will send them around to you. So I do hope tangentially I've answered that question, Judge Ferrari, and I'll hand over back to you. Thank you.
Thank you so much, Professor Mason. And now we go back to Professor Grimm, asking the question, with AI technology evolving rapidly, how can courts ensure that judges and legal professionals are equipped with the necessary knowledge and skills to effectively evaluate and understand AI-generated evidence?
Thank you very much. To pick up where Professor Mason left off, the outcome, the ability to explain to lay individuals, which many lawyers and judges are, because they lack the technical expertise. And there's really no one particular type of expertise that fits all shoes when we're talking about artificial intelligence. As Professor Mason correctly pointed out, you have statisticians, statistics, you have computer design engineers, you have individuals who may be looking at making assumptions with regard to identifying questions that can be asked to determine predictability of future criminal behavior. So it may involve psychologists, it may involve criminologists. You may have many different types of specialties involved in one design of a particular artificial intelligence software application. So There's an old expression that no judge and no lawyer wants to be in a battle of wits unarmed. And we are unarmed with regard to much of the information that is involved in this highly sophisticated computer technology. Moreover, the experts themselves are limited in what they can provide to the fact finder about how the software was trained, or even how it was, the algorithm that manipulates the software was prepared, because machines, once you started to train the computer with the data, and we are now doing that with, as Professor Mason said, large language models where there's enormous amount of data, the machine then takes over and starts writing its own algorithm. And so that the humans who initially designed are no longer involved in all aspects of its development. So what you need to do is you need to make sure that this ties back to the judge's responsibility. And when I was a federal judge in the United States, this is the pretrial management responsibility of the judge to make sure that there is advanced disclosure by the parties that intend to rely upon evidence generated by computers as to what that evidence is, so that the opposing side and the court know. That's number one. Number two, the court needs to make sure that there is a pretrial schedule during which those parties who will be opposing or potentially opposing the computer-generated evidence have an opportunity to learn about the evidence in that particular case, disclosure, and have the opportunity to go to their own experts and experts in the way that it's colloquially used, not the way in which Professor Mason used it when he was in the Royal Army. But you have to have someone to try to unpack it. Now, this creates a problem that many are concerned about. I think all of us on this program are concerned about, is equal access to the technology specialists that you will need, because not everybody has the funds to be able to do that. And so that's going to be an access to justice issue that the courts will have to wrestle with. Because if one side is going to have an expert and the other side doesn't have the funds to test it, then that's going to create an imbalance and make it, for all intents and purposes, difficult for the opposing party to mount a credible challenge, and the judge to rule, frankly, if there's not an opposing side to the evidence offered in support of the evidence. Then what has to happen is the court should set a deadline by which the party that intends to challenge the evidence will identify that desire to challenge the evidence and the basis for that challenge, and the opportunity to have a hearing at which any side that has technical expertise that they want the judge to consider comes forward and presents it, so the judge can hear both sides and make a principled ruling. This procedure is clearly important in criminal cases where there is a serious possibility of a serious and lengthy incarcerative sentence if there's a finding of guilt. The structure breaks down in jurisdictions where you have thousands and thousands of cases and the parties don't have access to these. And that's simply going to be a challenge in the future that many organizations such as UNESCO are coming up with principles that should be adopted to bake into the development of the artificial intelligence applications, so that they have trustworthiness and explainability built in. And then the proponent would have to be able to disclose that prior to the evidence coming in. It is critical to keep in mind that, as Professor Glass indicated in her excellent opening comments, judges have a responsibility not to let the party that has developed the artificial intelligence software hide behind the curtain of confidential commercial information. And some judges in the United States, and I think appropriately so, have held that if the party that wants to introduce evidence that's the product of artificial intelligence software applications, they have to permit some level of disclosure subject to a fair protective order in order to get the evidence in. And if they choose not to do so because of confidentiality, then they can't use the evidence. And they just have to decide what's more important, protecting their commercial property or allowing it to be examined by those who will not disclose it to a competitor, but will enable the litigants and the judge to have sufficient information. Then the judge has to rule based upon the evidentiary principles that govern the admissibility of evidence that may be relevant, but only if it's reliable. And when those steps are taken, that's the best that the system can presently offer to make sure that the lawyers in the court have the information necessary to determine whether the evidence comes in so that there is not an unfair risk of an unjust outcome of the litigation. And I'll turn it back over to our moderator.
Thank you so much, Professor Grimm. And now we head back to Professor Mason, and we're talking a little bit about his book. Professor, in the 50th edition of the practitioner textbook, Electronic Evidence and Electronic Signatures, which you added with Professor Sang, in chapter 4, entitled Software Code as the Witness, you talk a little bit about this topic. So could you provide some more details on the effect of software code on the presentation and admissibility of electronic evidence in legal proceedings, particularly in the context of AI-generated evidence?
Thank you, Judge Ferrari. I'll try to be as short as possible because I appreciate we're running out of time, and it would be good for questions and answers, obviously. Professor Gless did mention machine testimony, or forgive me if I'm the Centre of Telecommunications at Governments in New Delhi mention machine testimony, and the point is we are obviously in the world of machine testimony now and have been for some time. What we do in the text is actually split machine testimony into three. The first category is content written by one or more people, so that could be the records of electronic content such as email messages, word processing files, and instant messages. And now, unless the author of the software has included instructions in the software to alter the content of the text, which has been typed in by a human, then the only function is to produce with an email what was written by the human being. In that case, the content of the software itself is not relevant unless you have a dispute about what data was entered and the time it was sent and by whom and such information like that. Then we have category 2, which are records generated by software that have not had any input from a human being. And examples of this are software controlling a computer, such as computer data logs, for the purposes of tracking activity and diagnostics, number plate recognition software, automatic connections made by telephone switches, and the records for telephone billing and such like. In a case like that, again, you may be happy with the accuracy of the output, but you might also be challenging the accuracy of the software that produced the output. And then category 3 is the records comprising a mix of human input and calculations generated by software. The example would be financial spreadsheets that contains human statements. So if you fill out your own money received in one Excel spreadsheet and money spent in another Excel spreadsheet, then you are inputting the information into that spreadsheet. But then if you ask the software in a spreadsheet to add up or subtract any amount in there, then you are depending on the software writer or writers to have written an algorithm that gives you an accurate result. And that's where it's possible, from the evidential point of view, the issue might be whether the person or the software created the contents of the record, and how much of the content was actually created by the software and how much by the human. As you can tell from our discussion of artificial intelligence in a context that Professor Gless mentioned in motor cars and Judge Grimm mentioned in big systems, a lot of these lines blur, and that's going to be a significant problem in the future. I think I will leave it at that to allow some more questions fairly quickly, if that's all right, Judge Ferrari.
Thank you so much, Professor Mason. And now we welcome Professor Andrew Rains. He's a senior research fellow at ICT Africa, attorney, academic, and policy advocate with an excellent history in public interest, focusing on information communication technology and intellectual property issues. So Dr. Rains researches AI policy, data governance, and regulation of the digital economy. And he also completed recently his research on AI and cyber risk and data policy capacity building. Welcome, Professor Rains. And
thank you very much.
And for you, we have the following question, a very broad question, actually. What ethical considerations should be taken into account when dealing with AI-generated evidence, particularly in terms of privacy, data protection, and potential biases in the underlying algorithms? You're muted.
You're muted, Dr. Rent.
There we are. Yes. So I think that the starting place must be that we recognize that AI is often trained on private data, and that when we think about whether there's consent for the use of the outputs of that AI, which may include personal data or private data, that it's not possible to get that consent up front, right? The AI might have been trained on data where consent was obtained for the primary use. Let's say it's a financial program and the people consent to use for some kind of financial analysis, but later on that data and or the output from the AI from which data can be inferred, or which constitutes data itself, personal data itself, is then used, then that can be we can't demand consent for that. But we can say there's a public interest in making use of the data, and that public interest is obviously for courts to be able to function and have evidence before them. But that means, though, that because certainly in laws across Africa around data protection, that courts are going to have to ensure that it's ethical use, right? So courts are going to have to, because generally they get a carve out to look after their own process from GDPR type legislation across Africa. They're getting a carve out, and so now courts are going to have to take that responsibility and figure out, well, maybe we'll permit the use of the AI evidence that does implicate personal data, but then we put a ban on people using it for any other purpose. It needs to be redacted from the decisions, which are obviously very important in the common law jurisdictions of Africa, where we want reportable decisions because of precedent. So there what we see is that responsibility is going to have to devolve onto courts. And I think because we've got such a broad range of different kinds of legal systems across Africa, and then I can probably generalize that to the rest of the world. So that's great. But then what about bias and fairness? And of course, this takes us to the issue of scrutiny, which two of the speakers I think I mentioned before, Professor Grimm at Duke, and here, as already been discussed, we've got sets of claims around that algorithms are proprietary, and neither patent law nor copyright law, they both sort of exclude algorithms generally from their ambit. So trade secrets has become this default claim. And what we're seeing is across Africa and across the developing world, claims that governments in Africa, where trade secret law is very underdeveloped, should be granting sort of very strong trade secret status to algorithms. And so my view, based on my research, is that African governments and developing country governments generally have to resist this. That to the extent that there is any trade secrets in algorithms, and in most African jurisdictions, this is not a question that's been resolved in any way. It must absolutely give way to the public interest in transparency of algorithms, including in evidentiary hearings, including in enabling people to challenge them. But we know there's going to be resistance for that, and but basically anything else is, contrary to the rule of law. If courts can't scrutinize something because of an alleged proprietary claim, then that's contrary to the rule of law. And so I think that has to be a very firm line in the sand. There's probably a whole lot more to unpack in that question, but I'll stop there.
Thank you so much, Professor Rains. And now we head back to Professor Grimm with two questions. The first one is, how can courts strike a balance between allowing the introduction of AI-generated evidence to enhance decision-making while also safeguarding the rights of the accused, including the right to a fair trial and the right to challenge the evidence presented? And the second one is, what measures should be implemented to prevent tampering, manipulation, or malicious use of AI-generated evidence in court proceedings?
Thank you very much. We've already talked about some of the steps that need to be taken to protect the balance of introduction of evidence in judicial decision-making, to balance that against the right of the accused in a criminal case to have a fair trial, or a civil litigant in a civil case to have a fair trial. And that, just to briefly recap without spending much time on it, falls with the judge to set a schedule that requires for disclosure access to information, to include, subject to a proper protective order, the information necessary to be able to challenge the AI evidence, but protect against its use improperly by a commercial competitor. And then a schedule to allow a challenge to be made and the judge to have input from those with sufficient knowledge to be able to answer the questions about transparency, reliability, validity, however you wish to disclose the notion of that you can trust this information to be sufficiently accurate and reliable enough to make an important decision in a case without running the risk that there will be an unfair outcome. That's a separate issue from once the information has been produced, what do you do to make sure that it's not manipulated or used for an improper purpose? One thing that courts can do is to issue orders in cases that restrict who has access to that, have them sign or acknowledge that they have knowledge of that court limitation, and that if they use it for a purpose other than what has been approved in the litigation, that can subject them to contempt of court. Additionally, there's a technical solution too, in that data can be provided in a format that, for example, the audience I'm sure is familiar with, when you take information from a digital device, you can put a hash value on that indicates that it was in a particular format, and if it's altered after it has been produced, it is capable of determining that it has been altered after it's been used. That is simply a technological issue as to how it requires two parts. The first part is for the court to issue an order that limits the permissible use and make sure that it applies to all of those individuals who might have access to it, so that if they violate that, they can be held accountable for it. And number two, a technical solution, which is how do we make sure that the format in which this information has been provided cannot be manipulated after it has been disclosed and used for an improper purpose in the case. And with awareness of how the schedule is, I'll stop right there and turn it over to our moderator.
Thank you so much, Professor. And now we head back to Professor Mason, asking him the following question. Given the increasing prevalence of AI-generated evidence in legal proceedings, and considering the principles outlined in the draft convention on electronic evidence, how can we effectively address the admissibility challenge posed by AI-generated evidence to ensure fairness, reliability, and trust in our justice systems?
Thank you, Judge Ferrari. Again, I'm going to be very brief on this because I think what has been demonstrated in the last hour is how complex this is. When we first drafted the draft convention on electronic evidence between 2015 and 2016, I did so because I did a lot of seminars with the Academy of European Law based in Trier in Germany. And I think we were in Budapest on one session, and somebody in the audience said, "Why isn't there a convention on this?" And I said, "Well, I wonder why there isn't. I really wish there would be." And so we decided to write one. Now, you'll have a link to this in the materials sent around by the UNESCO. But Article 2, it's a very short draft because it was just a starter. It was never meant to be something which was going to be comprehensive. But if we just look at Article 2, which is the admissibility of electronic evidence, Article 2.1 says evidence in electronic form shall be admitted into legal proceedings. And Article 2 says Article 2.1 does not modify any existing national rule that applies to the admissibility of electronic evidence, except in relationship to the rules relating to authenticity and best evidence. And then Article 3 goes on to the agreement on relating to admissibility. Now, probably I'm not going to answer this question directly, but to say everything has moved on so much since then, and the complexity is so much more that we have to go back to the drawing board, I think. And on Tuesday, I took part in the European Law Institute event dealing with proposals for a directive of the European Union for a directive on mutual admissibility of evidence and electronic evidence in criminal proceedings. And they have produced a very good draft directive, which is far better than one we did in 2016 and much more comprehensive, although it does miss some items out. There is a link in the references, and I highly recommend that. But what really comes out of this discussion today is that everything is so complex, and as Judge Grimm says, the costs are going to be, they are already prohibitive in some cases. And many people who are accused of crimes just do not have the money to be able to afford appropriate help technically, which is leading to unfairness in legal proceedings in both criminal and civil legal proceedings. And it strikes me that we have to do something very quickly. Just before I go, I did forget to mention that Professor Gless mentioned the possible prosecution of somebody in a car which is being driven under the autonomous software. Well, certainly in Switzerland, there was a case a few years ago where a Swiss citizen was prosecuted driving a Tesla under automatic control, and the car smashed into a stationary object. We have published that in the journal, and I've included in the list of articles I've sent over to Charlene and her colleagues at the UN. So I'll leave it at that because we obviously need time for questions. Thank you very much.
Thank you, Professor. And now we'll go back to Professor Rains, asking him about the Global South. So in the Global South, we're primarily engaged in discussions surrounding the admissibility of electronic digital evidence. How has this debate been progressing in your region? And based in your experience, how can we proactively prepare for future admissibility challenges related to AI-generated evidence? I think you're muted.
Yeah, I've now unmuted. Thank you. So what I would recount is that the pace is slow in Africa. So last week on June the 8th, the Malabo Convention, which includes important provisions on both personal data protection and cybercrime, came into force. And so this is the first Africa-wide treaty on these issues. And it dates back to being negotiated in 2011. So as you can imagine, it's already out of date. The good thing is that there's a lot of excitement around implementation. And so we may well have an effect where there's a lot of implementation in African countries that goes well beyond what the text requires, because governments and parliaments will be actually looking at these issues now, and they'll include some current issues in their national legislation without waiting. And they'll draw some guidance from the African Union data policy framework, which is intended to guide exactly these kind of things and which is far more up to date. So those are positive, but at the same time, I'd say there's still a little bit of lagging. But one of the debates that, particularly if you look at South Africa, which is my home country, was how there was movement from admissibility to weight. Now, I understand that not all systems care as much about weight of evidence or even think of it in the same terms. So for the French speakers, l'importance de la preuve, it's in common law systems, weight is how much you can let the evidence in, but you may not have a high regard for it. You may weigh it off against other evidence. And so in South Africa, what we had was a situation where we previously only admitted computer evidence if an expert could say that, or at least someone claimed to understand how the computer operated, that the computer was operating, correctly at the time. And so obviously that's just not possible for the average user of a PC to say, look, I'm running Microsoft. Even Microsoft or Apple don't know all the bugs in their code. They're finding new ones all the time. I know the computer was running correctly at the time. And then you also had to prove that every computer to which that computer was connected was running correctly at the time. Now, if you're connected to the internet, that's obviously not possible. So that would have just, that law was written for mainframes and was out of date. The new law basically said data and messages are admissible, but the weight given to them depends on a whole set of factors: how they were communicated, how they were generated, how they were stored, essentially what the train of evidence is since then, who is presenting it. And these are exactly the kind of questions that people have been mentioning earlier. The question, though, in a developing world context is, are we going to say to people, you both need to hire experts, let's say the state and an accused, or two parties to a civil case? And that seems just prohibitive from a resource perspective. So one solution is that in a criminal case, it must be the state. In a civil case, probably the party bringing the case should pay for an independent expert appointed by the court, who will then give a narrative to the judge. I assessed the AI produced evidence in these ways, saw whatever chain of evidence, whatever explicitability was available. And so not just give an opinion of like, well, I think it's good or it's not, but like explain, give a basis for a judge to decide admissibility, but also to decide weight, because you might say, well, if it's the only thing relied on, it's not enough. But if it's, and the marvelous thing about evidence is then you can say, but if it concurs with other evidence, if we have some supportive things, then you can go with it. So the idea of having just a single independent verifier of complex technical facts does have some examples. Courts do sometimes do that, for example, in South Africa. Interestingly, in the context sometimes of medical claims, but also of children, right? A separate court-appointed psychologist will talk to the child and come back with an account of what they said and what their methods are and what they did. It's still contestable by the parties. And I guess they still could get their own expert in, but it enables a slightly less resource-intensive approach for developing countries.
Thank you so much, Professor. And our last question goes to Professor Glass again. So, Professor, what lessons can be learned from jurisdictions that have already dealt with the admissibility of AI-generated evidence? And are there any best practices or precedents that can guide the admissibility process?
Thank you very much. I think we have already heard quite a bit about that and heard it repeatedly, perhaps, and already have started to engage in some what I would call a comparative view. So if I take it back to Professor Renz and also to what the previous speaker said, I think in all of our jurisdictions, the majority cases is dealt with plea bargaining. These cases don't even go into a courtroom. In the majority of cases, defendants will be faced with what Professor Mason called the scientific, presumably scientific evidence produced by a computer. And they have to run their chances. What will happen if I try? Like in the way I described it to you in my keynote at the beginning, if you are faced with the choice to go against a car maker because you feel you have been awake, perfectly able to drive a car, but your car thought that you're not able to drive. You don't know why. Could be the car is biased against the way you look because it thinks you look tired, or it's biased against the roads you drive on. Talking about the global south or rural areas in Europe, these cars are trained on looking at the middle lane. That's what they try to find. So if you drive on a road that has no middle lane, the car will constantly think that you are on the wrong side. It thinks that the left side of the road is the middle lane, and it will beep on you. Now you're a defendant in a rural area and your car alerts you to being drowsy. You know you're not. You're faced with the evidence, and then you have to make the decision whether you plea bargain the case, take a lenient judgment, plea guilty, or whether you go against a car maker. And I think we cannot give enough weight to what Judge Grimm said. Then it's a question of who has the funds. And I think it's an easy to answer question if you look at the two people, the defendant in a rural area, in the global south, wherever, where a car could be biased against the driver. Still, I think if you want to take the lesson of jurisdictions or cases that have gone to court, I think what we learn, and that's now for the audience, all the trial judges and defense lawyers and prosecutors out there, I think you should go back to very basic good forensics, and you should start to ask,
Yes.
Can I find any raw data? Can I, if we go back to what Professor Mason said, the moon. We know there's the moon because we have raw data, but also in cars, you can have raw data, skid marks on the streets, other things that you can actually bring to court. And then you have to ask all the other questions to the expert, who then sort of is a mouthpiece to what the AI system would say. And now I come back to the comparative question. I think in that situation, actually, what we call inquisitorial systems may have an advantage because the expert is court appointed and can give access to both parties. So it's not like in adversarial systems where both sides will have their expert. And again, you need more funds. And then you can ask the questions of traceability that we have talked about, the raw data, how is it processed? What are the relevant algorithms and so on? And then a very important question we have touched upon, not have enough time to discuss it, is reproducibility. That Judge Grimm explained, that goes to validity. Can you reproduce the AI generated evidence? Not possible with with drowsiness alerts, because you cannot go back to the same. You don't know how much data the system actually took from the surroundings. And I think that is where maybe most people in a courtroom can be convinced that some data is just merely unreliable. I would now take the option to answer a few of the questions that came up in the chat and that we have not talked about. So one of the interesting questions, it is interesting for me as a criminal procedure scholar, is the question whether if we use this evidence, like evidence generated during a car drive, and hold it against the driver, don't we violate the privilege against self-incrimination? And that also goes a bit to what Professor Renn said. You know, there's more privileges out there. It's not only reliability. I have discussed that whenever I met some car forensic expert, you know, what do you think about that question? Is it evidence that I have produced against myself? So one of the answers was, if I break a car and I leave skid marks on the road, I cannot claim that the skid marks cannot be used because I produced them and now I produced evidence against myself. However, I think, and Professor Mason said that, you know, the line blurs. I think there is AI generated evidence where we would grant the privilege against self-incrimination, especially, and that is now cases from the US. If you use a pacemaker, a heart pacemaker, to follow the steps of a person who is suspected to have killed his wife, and by the body activity, you're able to make a good case that most probably someone killed another person and then threw, in that case, her out of the window and then lit fire to the house. So are you allowed to use the data from the pacemaker? Are you allowed to use data, AI-generated data? Diabetics would be another case, where the person, by just being able to survive with AI systems, produces evidence that can be used in a criminal court, that can be read out. So I think that's a very interesting question. I only raised the question. The answers, perhaps someone will engage in our chat and has an idea about that. Thank you. I turn it back to the moderator.
Professor Grimm?
Thank you very much. Let me take a stab of that. This is a great question because obviously in the context of the falling asleep at the wheel or being too tired to drive without doing so negligently example that Professor Glass has said, it's going to be information taken about the defendant from the defendant's own car that will be used against them. The key to the answer to this is when you're identifying self-incrimination and what the limits are, the line between what's acceptable and what's not. In many jurisdictions and in the United States, what the rule is that it has to be a testimonial statement. What you can't be compelled to do is testify against yourself. And you can debate where that line is drawn, but in the US court systems, for example, you can't compel a person to admit that they were at the house or to admit that they were involved or knew about information that would be incriminating. But you can require, for example, in a lineup, if a person is being put in a police lineup for a victim or a witness, to identify whether one of the people in the lineup is a person who can be was present at the crime. You can require them to turn left and turn right, or if the person uttered a threat, give me your money or I'll fire this gun. You can make each of the people say, give me your money or I'll fire this gun. And that is not considered to be testimonial. Now, you can argue whether you think that is right or not right, but the line is drawn as you can't be compelled to give testimony against yourself, not that every bit of information that implicates you either directly or circumstantially to the charge brought against you cannot be used against you because you're in it. And if you are in it and it was your activity that is incriminating you. I think that's where the line is drawn in this country. I'd be surprised if it's not drawn similarly in other countries as well. Forced testimony is what the basic protection against is, but not all evidence against you is testimonial evidence. And the question we then get is the computer testifying? And the way in which most judicial systems have answered that is, no, it's not an individual providing testimony. It is a machine that is providing digital evidence, and it's an issue of authentication, reliability, validity, not of testimony. But yes, this line becomes blurred in the area of artificial intelligence.
Professor Rains?
So just briefly, so I think we need to ask ourselves, what's the rationale for the privilege against self-incrimination? And my understanding is that the primary rationale was to prevent people being coerced, right? Being threatened and us signing confessions, etc., because they were being coerced. And it doesn't seem to me that using AI triggers that rationale, right? There's not an element of being coerced to testify against yourself. But there is a secondary argument for it, which is, you know, how do you live with yourself if you sort of testify against yourself? It's a similar rationale for what many jurisdictions have, a spousal privilege, that your spouse can't be testified to testify, can't be compelled to testify against you, because, you know, what does that do to a marriage at the end of that? So similarly, you know, how do you live with yourself? And so when it comes to medical kinds of things, you know, I've always thought that this idea of the pacemaker, or this thing that's integrated in your body, how do you live with it if it's testified against you? It may not be cursed in a sort of original sense, but how do you know? And so I think I don't have answers. I think those are the important questions. Why do we have the privilege?
Thank you so much, Professor. In the last hour and a half, we've talked a lot about the admissibility challenge, and we have addressed its legal, its ethical, and its technical problems. So as we have only some more minutes, I'd like to ask you, professors, what would you recommend to our audience? Our audience includes legal professionals like lawyers, judges, law enforcement officers, and legal scholars. And it's a topic that is still difficult for many of them. So where do you think they should start?
I'll start if you like. And I would say this, wouldn't I? I just hope that the book that Professor Seng and I edit, together with a list of other authors, would be a good starting point broadly. It's only a starting point. I've tried hard with the journal I founded in 2003 to make that international as well. But doing a lot of work with the Academy of European Law and others, training, we've got lots and lots of trainings to do, and I sympathize with everybody listening to this right now, regardless of in what profession you are in, because it's a serious issue.
I would say,
pick up. I would just call, what I would not suggest you do is to go to ChatGPT and say, tell me everything I should know about artificial intelligence. That is what you should not do. You go to Professor Mason's book.
Professor Glass,
I would say open your eyes. Every morning you get up and you engage with a device that is driven by artificial intelligence. And it does what you want, or it does not what you want. And it's recording. Then think about, would I allow this as evidence in a criminal court against myself, against my children, against whomever?
Thank you.
And think about, how could it be tested? How could it be validated?
Yeah.
In your jurisdiction, and then you can write a little note and send it to the professors. We are all very happy to learn about it, because that is the thing. We know very little about what's happening in the different jurisdictions. Thank you. I hand it back to the moderator.
Yes.
Thank you so much. Any advice, Professor Rains?
Yes, I would say do read Professor Mason's book, particularly for people coming into this from outside of evidence. So there are people who are primarily concerned about AI regulation and bigger questions of AI policy. Questions of evidence might seem as if they're just a sort of small specialist area, but they're not, because if you can't prove AI does something or doesn't do something, if we end up with a sort of, it gets a pass in evidence, we always trust it, then your policy aims or your risk aims or your regulatory aims fail. So if we can't get a proper evidence regime for AI, generated evidence, then the other pieces, the big sort of substantive legal pieces that we rely on don't work. And I'm sure, you know, the other professors and the judges will agree with me that these kinds of sort of less regarded procedural things are really where action happens. And if they don't work well, then your substantive law is actually not going to work well.
Yeah.
Thank you so much. Does anyone want to say something before we end? No? So I'll just like to thank all of you for sharing so much knowledge with us. So I thank all the participants. I would also like to thank Charlene and Pratik for putting this event together. It has been a great opportunity to hear about this amazing topic. I would like to thank all of the 300 participants that have been with us for the last 90 minutes. And with this, I hand the floor over to Pratik again.
Thanks, Judge Ferrari. First, I would like to also thank my colleague Charlene, who's done a lot of work in setting this up and has been in contact with all of you. And thanks to all the speakers. I think we would the nuances in this discussion would require further reflection and perhaps even a longer conference around these issues. And we will definitely try to engage. But already I see that there's a community forming. I'm getting a lot of emails every day from the participants for resources and for them to be linked with you. So I think that's already a great start as we're building this movement around artificial intelligence and how to address some of the challenges. We'd like to invite you to the final webinar in our series, which will be on 6th of July, which is going to be talking about virtual reality and how our judges dealing with it. And we actually have a judge from Colombia who had a proceeding in the metaverse. So would be very happy to engage going forward as well. Thank you so much to everyone and to our interpreters as well. Thank you. Bye-bye.
Yes.